think when last we met, we were going to start with the Alona case, am I right? The adoption of Alona, which was the last one for that day that we didn't get to. Ring a bell? Yes? Everybody's plugging in? Ready to do Ilona. Ilona. See, everybody's taking a little vacation from juvenile law lately. What's going on? Hello. Joe, you look like you have something there.
No, I'm trying to refresh. I forgot that we had this case to do.
My reboot is slow. But I think Todd said he wanted to.
Really?
Yeah. He had texted me a couple minutes ago.
I move my friend.
Give him time to settle in a little bit. How about if I ask a question then? What was Mother's issue? Her fitness or unfitness? What were Nicole?
Okay. She didn't dispute that she's currently unfit as a parent, but she says that it's temporary. So the judge should look at it more as a...
And what was her unfitness?
It was a level of intelligence.
I'm sorry?
Wasn't it a level of intelligence? Cognitive?
How did the case
abuse.
start?
Abuse.
What kind of abuse?
Physical.
Yes, okay. Then she had other issues as well, right?
Yeah.
But physical abuse is how the CMP case started in the first place, right?
Yep.
Okay. So at what point, or at some point, did DCF change its goal to adoption?
August 14, 2007, the department changed its goal.
Why?
Because the mother wasn't really doing what she was supposed to be doing. She was in classes and she wasn't learning anything. You know, she was in a therapist who diagnosed her with depression and all of that, so she kind of had no desire to do anything to kind of help her. Also, she also had a learning disorder, so she wasn't really grasping anything that they were teaching her on how to be a parent.
So she was not, A, she wasn't compliant with services, and B, her own readiness, capacity, etc., fitness to parent wasn't really being rectified by the services that were out there because of her depression, because of her cognitive abilities, etc. Okay, all right. So case goes to trial, right? And it's a combination C&P 210, right? Because DCF, you just said, Nicole, had changed its goal to termination,
Yep.
right? What other issues are presented at trial and that the SJC rules on?
They were also stating that the mother couldn't meet her daughter's emotional needs because there really wasn't much of a conversation going on between child and mother. There was no bond really there, so they felt that emotionally the mother couldn't have been there to support her daughter. They said that that was also a problem as well.
So, in terms of this mother-daughter relationship, what was the mother arguing for? What sorts of rights?
Visitation rights.
Visitation rights, right? She knows she's gonna lose. She knows she's gonna lose, but she still has, parental rights until termination. And also, it's possible as a result of a combination C&P 210 that the court could order, right, post-adoption visitation. If what? What's the test for the juvenile court to, because all parental rights are terminated, but it is possible in some instances for the juvenile court to order post-adoption, post-termination visitation between mother and child, father and child, parents and children. But what's the test? What's the standard for that, Jim?
In determining visitation after adoption, the judge must decide whether the visitation is in the child's best interest. And second...
So you answered the question so far. The test is best interest. But remember that when we studied the care and protection cases earlier, when visitation is brought up in the context of a pending C&P and DCF is refusing visitation, right? So you say you have a case where it's an ongoing care and protection case, you represent mom and or dad, they call you up and say, I haven't seen my kids for a month, right? And standard is different then, right? DCF having custody, sure, can control visitation, has other rights as parens patriae, as a parent would have in custody, but can't terminate visitation during the pendency of the C&P unless what? It's not best, in that case, it's not the best interest test like we just talked about, it's a different test. Do you remember? The DCF could not terminate visitation before this stage during the pendency of a care and protection case unless what? What does DCF have to do in order to terminate visitation? Jonathan, do you remember? It was one of the custody of a minor cases that we read much earlier.
Don't they have to make efforts to get them back together?
Well, that's the reasonable efforts requirement that has to do with getting them back together, but that's different from just terminating visitation. So a parent, even in a sexual abuse case, Lee, the dad that we talked about, he had visitation rights right until the end. Suppose that at some point, the social worker went to her supervisor and said, you know what, I don't think Lee should see his kids anymore. Could they just inter-office decide that? Lee calls you up and says, you know what, I arrived for my regular visit and they weren't there. Nicole, you had your hand up?
Well, the two questions I think you might be referring to, it says that the judge has to ask two questions to order the visitation. One is...
Wait, let me just stop you for a second, because you're looking at Alona. I'm asking a different question.
No,
Oh, okay, go ahead.
Okay. I don't know. Never mind. I don't know. Maybe it's is it necessary? Like, between...
And the question I just asked,
Yeah.
we called you up and said, blah, 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 you know, they're not letting me see my kid.
Yeah.
All right? Can DCF on its own? Jonathan is saying no, and you're right. What does DCF have to do?
Give consent to have a process of like.
Yeah, what's the process?
A hearing,
You're right, yes.
I don't know what the exact
So the
process is, but.
DCF, remember, has to follow its rules and regulations. The 110 CMR, offering the visits, the service plans, placement with family, blah, blah, blah. In order to terminate visits, all right, have to go to court and convince the judge that what? The termination of visitation is okay because why?
It's in the best interest of the child.
No. It's a different, that's what I'm trying to point out. It's best interest for post-adoption visitation is the standard. For visitation during the pendency of a care and protection, before it goes to trial, in order to terminate visitation, the judge has to be convinced that what?
Parent's unfit.
Not unfit, it doesn't rise to that level, but think in terms of the parent-child interaction.
There is none? There's no bond?
Well, again, not even that much. Suppose you're the parent. You want to see your kid, your parental rights have not been terminated, you haven't lost permanent custody, DCF just has temporary custody. You should be able to see your kid unless, what? Think of the effect. What did you just say?
Pose a risk of harm.
Exactly. Harm. But DCF can't on its own just, okay, social worker going to, as I said before, supervisor, hey, we should just stop visitation because, when we go to trial, we're going to win. Right? Doesn't happen that way or shouldn't happen that way. It's a violation of parental rights. Go before the judge and you can show harm. Suppose you have an expert report, the kid was coming home, nightmares, has stopped eating, has been cutting himself, etc. Okay, then you can show that the parental visits are harming the child and therefore should be suspended, indefinitely or until, etc. But it's during the pendency of a care and protection case. So the parental rights are higher because they haven't been terminated yet. Whereas a case like Alona, mother's rights are getting terminated. So the only way that the judge is going to order visitation, now the focus is on the child, the best interest of the child, which could also have to do with harm. So that's why it might get confusing for you. A judge didn't order it, Nicole said. In spite of what? What kind of evidence did the trial judge hear about the visitation issue during the Alona trial? What was foster mom saying? Who was, I believe, the pre-adoptive home? Who now, after trial, was going to become the adoptive parent with now all of the parental rights that the prior parent had, right? So my mom is saying, okay, I lost my parental rights, but I should be able to visit because this is my child's best interest. DCF, I'm not sure what DCF's position was on visitation. Foster mother had a position on visitation. Foster mother's going to be adopting Alona, right? Did she want the kid to visit, Laura?
I think she did.
She did.
Yeah. And
She's like, yeah, I support visitation, I'll work it out.
Yeah, she said it unless there were any future issues, she would support it.
But judge doesn't order it, right?
Right. He leaves it to her discretion because she's the parent going
No,
forward.
judge does not order visitation, correct?
Right.
And what does SJC say about that? Todd,
They said that it was an abuse of discretion on the part of the judge.
the SJC did?
The appeals court, excuse me, sorry. The appeals court concluded that the judge abused his discretion.
Okay, SJC now is reviewing appeals court, and SJC says,
The SJC disagreed.
yeah, the judge didn't err in not ordering visitation, in spite of the fact that foster mom is okay with it. Foster mom, which, as Laura said, now has the discretion of she stepped into the shoes, at least by the end of this trial, of a parent. Judge doesn't order it because judge makes findings and rulings, right, that all amount to visitation based on the list that Nicole just gave us about the mother, that wasn't in the best interest to have any connection with mom after adoption. So you want to keep that in mind in terms of, you know, what sorts of issues may come up at a termination trial, even when, you know, even when parents are not only unfit, but it's also in the best interest of the children to be adopted. Is it possible that there could still be some kind of connection with the parent that is losing all rights? And again, the standard is best interest of the child. The judge ultimately has that decision to make based on all of the evidence. Judge can be, you know, overruled on appeal. Depends on, again, if judge has made an error or abused his or her discretion in terms of the findings not being, you know, supported by the evidence. I'm sorry, Todd, you had your hand up.
Yeah. Question relative to, it seems like the question here was whether the judge included it in the order. What is the ramification of that relative to the judge putting that visitation post-adoption in the order?
In the order, in terms of so there's a number of things that are happening here. I'm adjudging the children or this child in need of care and protection, right? Under 11926, the mother, the father, etc., is currently unfit. Currently unfit would be based again on her capacity, such as her depression, her cognitive abilities, also her connection to the services that she's received or not received, utilized or not utilized, you know, the findings, not only the findings, but the factors under Chapter 210, Section 3, you know, those 14 factors. Has she utilized the services? Has she attempted to? Does she have an incapacity to begin with that she just, you know, the services can't really redress her fitness? So court not only finds her currently unfit, but then goes to the next step and makes a ruling that it's in the best interest of the child or the children that her consent to adoption be dispensed with. And that's one piece of the trial. Then the court also looks at, where DCF is normally the petitioner, is there an adoption plan? Who are the proposed adoptive parents? And the adoption plan may include, perhaps, some kind of post-adoption, you know, interaction. And it's usually very little, you know, postcards, Christmas cards, pictures, maybe. Visitation is really, it's not the norm. Not the norm, but what the court brings up that, you know, normally the adoptive parent becomes a parent with all of the rights, all of the liabilities, you know, of parents in the future. And when you think about it, why doesn't, you know, it doesn't become part of the order? Because the judge has determined it's not in the child's best interest. In reality, if there was any connection between adoptive parents and bio parents, they could certainly do it on their own, right? After the trial is over, but it's not part of the order because the court finds it's not in the best interest of visitation to happen.
So I think I'm understanding it correctly.
I mean, no one's going to arrest anyone if again there was some connection with adoptive parents and bio parents, and adoptive parents allow, because you know when you're a parent, you have the right to control, you know, your child and what happens with your child. Remember all of the parental rights cases that we talked about. But it's not part of the court's decision.
And
right?
The Supreme Judicial Court finds that it's within the judge's right to not put it in the order. Is
Exactly.
that correct?
And Judge didn't err because Judge first of all, made the ultimate ruling that it wasn't in the best interest, but supported that ruling with all of the incapacities of the mother. And the mother as related to her, as she related or didn't relate, right, Nicole, to her child. And that's pretty much it. So that was the last case that we ended with last Tuesday, and then you had the next two cases that started with Linus. Okay, so let's do Linus. Jim?
Just another procedural history. DSS filed a complaint, Caring Protection in 2002, and the juvenile court adjudicated mom and dad unfit to parents of their children, Linus and Malcolm. The court terminated their parental rights.
So, again, the two parts. Started as Care and Protection, goes to trial, court adjudicates in need of care and protection because parents supposedly currently unfit, but also terminates parental rights as well. Okay, go ahead.
And mom and dad appealed with the judge erred in ruling each of them unfit and determining their parental rights. And under the facts, DSS filed a care and protection in December of '92 alleging the parents were neglecting their two sons, Linus and Malcolm, ages like 3 and 2.
Yeah, they were very young when it first started. So what was some of the...
When the children were born, they were both tested positive for opiates and methadone.
Okay.
There was also a third child, Alice, and
She's later.
yeah,
Yep.
DSS also filed a CMP on her. She was placed in temporary custody, and she was eventually returned to the mother in, I think, around October of 2004, and she has remained with the parents since that date. She has Down syndrome and medical issues.
Just go back for a second. So
Sure.
besides the parents being drug users, what other concerns did DCF have about the parents at the beginning? Anybody know? Jonathan?
Didn't the parents try to have another family member adopt the children? And they were concerned that the parents didn't want to parent the children anymore?
Joe?
Homelessness?
Homelessness? Beginning. What were the concerns? They were on drugs. They were homeless. They didn't have housing. Unemployed. Kids had issues.
She gave false addresses to us.
She gave false addresses.
She had bipolar,
She had bipolar.
and I don't think it went into it, but it said there's a criminal history.
What's that?
But there's a criminal history.
Who had a criminal history?
It said, she summarized the mother's drug and criminal history.
She meaning who?
The caseworker.
At the trial.
Yeah.
Okay. So what were some of the services that were offered and that the parents had been actually compliant with Jim.
Well, until the goal was changed, the parents first had weekly 2-hour visits, then twice monthly visits of 2 hours.
What did you say? I'm sorry?
Until the goal was changed.
Yeah,
from,
yeah.
Care and protection to adoption, the parents first had weekly 2-hour visits, then 2 monthly visits for 2 hours. Once the goal changed, those visits were reduced to 1 hour monthly visits. And the judge found that the parents always attended the visits, and Alice had been present. Judge also determined that the parents did have the adequate parenting skills to allow Alice to stay at the home.
Okay, you didn't really answer my question, but you added some stuff that we want to talk about too.
Okay, sorry. What was the question?
What were some of the services that were offered that the parents either complied or didn't comply with? So when I went around and you guys told me they were drug users, they were homeless, they didn't have housing, there were some mental issues perhaps. So what is again, DCF has to offer services, right? And parents, either comply or don't comply.
They didn't get appropriate housing and they were drug-free.
They weren't?
They were continuing.
What was the status at the time of trial? Did they have housing? Yes. Were they drug-free?
Yep.
Yes.
I don't think the housing was adequate though.
What's that?
Housing wasn't adequate though for all three of the children.
There might have been some issue in terms of are there enough bedrooms, etc., right? Yeah, okay. What's really the problem with this case? From the viewpoint of the appellate court looking and reviewing the trial judge's decision to not only, adjudicate a need of care and protection, but to terminate parental rights. Nicole had her hand up first, I think.
They were supposed to be complying with parenting classes. They were supposed to be having screens for drugs constantly, and maybe I'm misunderstanding it, but they didn't provide the proof that they needed to show that they were sober and that they were in these classes.
Are you guys reading the same case I am? That's some of the evidence, sure, that the judge talks through. But what does the appeals court say about all of this? Joe, I think you're interested.
They say that the evidence they relied upon was stale.
Stale. So a lot of this stuff happened. They had huge issues at the beginning of the case. By the time the case comes to trial, remember, it's not only fitness, it's current fitness. And again, that could be still possible, because they had huge issues. It was a few years later. Court looks at the capacity and readiness of the parents at the time of trial. And not everything was fixed, right? Not everything was fixed by the time of trial. But how does the judge err in the eyes of the appeals court? Besides the evidence was stale, the evidence of unfitness was stale. Take that to the next step. This was a termination case, Todd. You look like you want to answer.
No, I was just going to say that they were talking about the evidence that the parents were unfit was not based on any evidence that came out at trial. What
because
came out
the
at
evidence
trial
was stale. Okay. What about the termination piece of it?
The termination, DCF jumped in there, and the decision said that the DCF actually exacerbated the problem by what you had brought up at the beginning of the class, that they, on their own accord, decided to terminate the visitation without court approval.
Okay, so that was a huge issue. The judge actually sat on the motions that the parents had brought for a long time, and then finally ruled on them at some point that, in fact, DCF had abused its discretion in just, stopping the visitation. But my question was, what about this extreme step? That's the language, too, of the appeals court. The extreme step of terminating parental rights. Joe?
The burden of proving current parental unfitness was not met. And,
Just
you know,
think of it that way, that, yeah, the burden is much lower, the test is much lower for just losing permanent custody at the end of a neglect and abuse, a care and protection case. But it's still high. It's clear and convincing evidence of current fitness. So you could lose relative to that, but for DCF or the petitioner to also be able to terminate parental rights is as the appeals court has said here, is an extreme step. Extreme step. Except for appeal, you have no other rights after this as a parent. And so court has to be extremely cautious and go through the evidence very, very thoroughly and conclude that not only the parents are unfit, but is it in the best interest of the child to terminate a relationship, to terminate a parent-child relationship. And some of it has to do with, again, you know, those factors that I mentioned in 210. Are you enabled for some reason? You know, maybe you want to be compliant, but you're so psychologically unstable that, you know, you just really can't utilize those services effectively. Or maybe it's the other way around. You just refuse to be compliant with DCF. Or maybe another factor is the kids have been, and they were in this case, in their pre-adoptive foster homes, etc., for such a long time that a bond has formed between the pre-adoptive parents.
that's what the judge tried to hide behind too. He tried to say that the fact that they spent most of their lives in DCF and made significant bonds was the real reason why he ruled the way he did.
Yeah, and sometimes it's, you know, the passage of time really, really hurts the parents who are attempting to be compliant. And they were, as Jim brought up, another child was one. By the way, Alice had special needs, and the parents were perfectly, you know, okay, and so was DCF, with the parents having Alice. So what does the appeals court do? It sends the case back down, and what is the appeals court telling the judge that she now has to do, Todd?
You either have to have a new trial or order reunification of the family.
Either have to have a new trial, if what? What would warrant a new trial in this case? What was the specific sort of mandate? So
the judge would have to show that there was...
Not the judge. So the first thing we're looking to is the department, right?
Okay. The department would have to show some sort of grievous shortcoming, putting the children at serious risk.
If that was in fact still the department's goal. Appeals court said, you know, all this time has passed, they're compliant, they have housing, they're no longer homeless. Is that really still your goal? If it is still really your goal, as you said, was, you know, new trial with new evidence, with current evidence.
And if it's not, the alternative, the court says that the department should implement reunification of the family with judicial oversight.
Two of my very good friends and colleagues were actually on opposite sides of this case, and if they finished with court Thursday morning, they promised me they'll try to come in on Thursday. So I'm sort of holding back to tell you more about this case. If they can't come out, I'll revisit the case with you, but I'm hoping that they both can come because they want opposite sides, which is really an unusual thing that they agreeing to come and speak together to you. So let's go on to the next case for now. Eduardo. What was parents' problem in Eduardo? Aniko?
The mother was given help to, help clean up her apartment. She was being taught how to secure new housing. She also had psychiatric problems.
Yes.
Where she refused to take a psych evaluation. So that was her problem. And she failed to continue treatment. She wouldn't go to see her therapist. And these are all different things that were on her service plan that she needed to do, and she just wouldn't do them.
And that's it. You have to be careful when this, when the parent has some kind of something wrong with them, whether it's mental illness, alcohol, drug addiction. The court has to be satisfied that there's a nexus between that type of disability and unfitness, especially to justify a decree of termination. In this case, it was met.
But you tried to turn it around on them and say that they weren't meeting her needs.
Exactly, exactly. DCF can only go so far in terms of its policy and its goal to strengthen and encourage family life.
It said here that DS's obligation was contingent upon her obligation to fulfill her end of the bargain. Like they can't be held.
Now, Imelda was a little bit different, right? What was the mother's problem in Imelda?
Drugs.
Drugs? What else?
She was domestic violence, she was abused.
Domestic violence, and there was something else.
Failure to seek medical care,
Yeah.
proper medical care.
Right. So, what happens by the time the case goes to trial?
She's completed detox.
Laura?
She's completed detox, she's living with her parents, so she's away from being abused, and taking care of her child.
She actually leaves the I don't know if they were married or not, but
No.
leaves the father like 11 months before the trial, well before the trial.
Yeah.
Yeah.
Yeah, she went into detox, she was there, I think, for 3 months, she was clean, had the support of her parents. And then they actually,
Who wanted to adopt, by the way?
her boyfriend, her mother,
Yeah.
who
Interesting.
whose partner was accused of domestic violence.
Exactly. And
rape.
and what?
Rape.
Yeah, and their daughter, she did something awful too.
This also brings back, do you remember the Vaughn case that you guys read? One of the reasons why it gets sent back down is, if there's an issue of domestic violence, the judge has to consider that and make findings regarding it. Go on, Laura.
So the other thing that happened through this process was her attorney said things when it came to trial. He said, I had a call from her, I went to return the call, I couldn't find her, her whereabouts are unknown. And yet her mother testified that at the trial that she has completed, or was in the detox, I think, at that
Right.
time.
Mm-hmm.
And it was ignored by the judge.
Mm-hmm.
So one of the things when it went back down was that she would get a new attorney. Yeah, that's, I think, pretty much it.
Okay. That is pretty much it. Now, the last two cases you have are very different because they deal with mothers that have Munchausen syndrome by Proxy. Who wants to review Wilhelmina for us? John?
Yeah, how do you pronounce it? Munchausen syndrome?
I know, I
It's
can't
when
say
you
it.
exaggerate illnesses and stuff like that. So this mother had that. It's also called FDP, factitious disorder.
Yes. Mm-hmm.
And custody of Wilhelmina was given to her father after she was found to be unfit.
What did mother do regarding Wilhelmina? What were the facts?
One of the first things that happened was she pursued a restraining order against the father, saying that he was vulgar and suggestive while changing a diaper for her. Specifically, though, is this the one where she refused to feed the child, or is that the next one?
Anybody want to chime in? Amanda, I'm sorry.
She, oh, which one?
Yeah, you.
Oh, okay. She would have the child ask before engaging in certain activities during visitation. She would only allow her to eat certain foods at certain times. I think this was the child that kept vomiting and throwing up. Her mother was like controlling of her behaviors.
Anything else? Joe, you want to add to that?
I'm sorry, what, did she say vomiting and gagging?
She was vomiting?
Vomiting,
Vomiting,
gagging, diarrhea, sleep issues.
Yeah. The mother, I don't know if this is after the fact, but the mother believed that when she was pregnant, she had a high-risk pregnancy,
Mm-hmm.
and that she had a C-section that was believed to be unnecessary.
Okay.
That just speaks to the potential Munchausen syndrome, and that, you know, she was in denial about it. She would, you know, when she did get treatment, the 2 times that she did go get treatment, it was with someone that was supposed to be a specialized Munchausen's doctor, but wasn't.
So John, you started to say before, what are the characteristics of, and it's typically a mother, so we'll say a mother, that has this syndrome?
Yeah, exaggerating illnesses and stuff. So she led her child to believe that Wilhelmina was sick. That's like how she raised her. So I think that's the crux of it, like why the judge thought that was.
What else do we know about these people that suffer from
They'll
this?
perpetuate a lie by inflicting injuries themselves, just to support the lie too. It said somewhere there.
Doing it for sympathy?
What are the characteristics?
Controlling.
What's that?
Controlling.
Controlling. Well, you say that and you're all right, they try to perpetuate that the child has certain illness. Do they necessarily have to know themselves something medical? I don't know if you're told this in these 2 cases, but I believe one or both of the cases talks about sort of a number of things. One is, mothers tend to have some connection with medical, not necessarily the nurses or doctors or anything like that, but they have some knowledge of the medical field. They also have a relationship with the spouse that is not good, right? And that's the case here as well. Now, Dr. Ayub would have been testifying about all of that, right? So in terms of an expert's testimony, what is the SJC, I guess, caution, later courts about? Laura is smiling.
Yeah, you can't use, profile evidence is totally inadmissible.
So what is profile evidence? I think we mentioned that, we talked about that once before.
Well, it's what we just did. So you say that, look, the profile of someone with this syndrome, is typically a mother, typically a healthcare professional, and the father's absent or, emotionally absent. And so that's profiling, and then.
So what is it okay? If you're Dr. Ayub, or the judge hearing Dr. Ayub's testimony, what's okay to hear and not okay to hear?
Do you talk more about the actual evidence? So, it's jumping a case, but in that case, she wasn't pleased when the boy started thriving. She wasn't supportive of trying to help him eat. So do you talk about the evidence that's relevant to that case rather than profile standards? Is that how that's what you should be doing in trial?
So if you're an expert on Munchausen, what is the purpose for you testifying? Right, Jim?
You have training in that area to recognize the symptoms of the disease.
Right.
And therefore, they can I would assume that they should be testifying to what symptoms they actually observed that would indicate that she had the disease rather than profiling and saying that these are the symptoms of the disease.
What's actually the, I don't know how to word this, but the way that you can 100% determine if a kid is actually, being hurt in this way by a parent who's suffering from Munchausen. How do you know for sure?
Keep them away from the parent?
Yeah. Yeah, and that's one of the things that the SJC says here. When she went to Dad and stayed with Dad for a while, all of those conditions went away, right?
Yep.
Or unfortunately, if the child dies or ends up with some real serious, medical as a result of. Getting back to the expert, so you can have the expert, as Jim said, who has been trained in this field to very generally describe, but the judge has to be careful that it doesn't go to the point of the expert testifying that this really happened because the expert knows, because the expert doesn't know, and that goes to the ultimate issue. And the judge has to be careful to not just, as the SJC said, adopt exactly what the expert says. The judge takes all of the evidence, right, and makes his or her own determination as to is termination in this child's best interest, and these are the reasons why. These are the findings of fact. Wilhelmina, vomited all the time with Mom. She doesn't vomit with Dad. That's a fact, right?
And good
Those
school-
are really
school
sad
attendance.
cases.
Therefore,
She had much better school attendance too.
Mm-hmm. And Keith was very similar. It was actually an appeals court case that was also touched on. Actually, I believe it was, if not the first, one of the first cases that went to appeal in Massachusetts on Munchausen. Laurie went.
sure. Just a quick, how often does this come through the department? Do they see a lot of this?
Well, IU was actually the department's one of the department's experts. Like, you saw her name often, I don't know that a lot of them have gone to appeal, though. Yeah, very weird cases.
Yeah,
Yeah.
so do you want me to do Keith?
Yeah.
So in Keith, I actually thought it was more serious than even the last one, because when he was small, when he was 6 months, he was hospitalized for an ulcerated digestive
Right.
tract. And then they put in 2 tubes, a G tube and a J tube, to give him nutrients. And it was after that she didn't really let him advance in terms of getting better, and she would never allow testing, feeding trials, things like that. And then there were a number of situations where they were, it wasn't obvious why the caps from the tubes were removed, and they were circumstantial evidence, but they'd find like the tube under her bed or things like that. And then he always had infections, and they generally thought that someone with a mother in the healthcare industry, he would have had less infections, not more infections. And
Right, she was a
constantly-
licensed part-time nurse, the mother in this case. Yeah.
And then they had found, part of the evidence was that she told his father that she needed barbiturates, or else he'd have to go on a morphine pump, and there had never been, a prescription for that. And it just went on, and then finally they filed the second 51A, the hospital did, and they kept him away from the mother, and he had a 24-hour-a-day sitter. They discontinued all of his meds, and then within 10 days he was eating apples, pizza, and chicken fingers.
I know.
This was really sad, because he was pretty old by then. He was like 7 or 8, so that had been his whole life. So that, when they talk about that actual evidence and they got away from the profiling, the mother, one of the things was the mother's lack of expression of relief or pleasure that her son was doing well and didn't need central lines or tubes. She had no pleasure at that. So she, one of her appeal things was about the profile testimony. And then they went through all the evidence that I just went through. So they actually disposed with her parental consent to adoption.
That appeals court affirms?
Yes.
Yes. And that it wasn't an issue of improperly admitting profile evidence, but again, you have to be careful about that the evidence comes in as syndrome, description of the syndrome itself, description of what's going on with the child, what particular facts of the medical condition could be as a result of something mother did or didn't do. Yeah. So what we're going to do on Thursday is, and I sent you guys an email just as a reminder, but it was in the syllabus. There's a link to this case that arose out of, I just thought it was New Hampshire or Maine, but the taking of Logan Marr, another crazy sad case. Take a look at it. You can actually watch some of the video from it. It was a frontline case some years back. So the link links you to the frontline video and materials on that case. We'll use that case sort of as a summary, of cases that start as 51A reports and go all the way to termination. And we'll use that a little bit somewhat as a review too. Now, if my guest speakers come, then you'll hear from the guest speakers. But, so take a look at that. And then next week we're going to do the mock hearings. It's the Sissy Harrison case. I sent it to you as a doc. Don't remember if it's actually in your packet or not, but I did send it to you as an attachment, so make sure you get my email on that. It's about a small little document, and I'll assign roles for you. We'll be doing a piece of her termination trial.
Did you just send that out? Like
I
last
sent it
week?
out literally just before class.
Oh, okay.
We're not doing it until next week, so take a look at it and see if you have preferences for any of the roles. We're gonna have Sissy Harrison, she's the mother of these two young twin girls. Then we have a court-appointed investigator. And then we have a few DCF workers, because she's a young mother. She was a result of her Caring Protection case was started when she was young in her family, so there's a worker that had worked with her when she was young, and then there's another separate worker that works with her when she becomes pregnant. She actually has believe it or not, a great-grandmother, that, this was a real case, a great-grandmother that has helped her out on and off, but she's been in lost or foster homes. And then we have a guardian ad litem, and obviously the attorneys for Sissy, DCF, and for the children. So take a look at it and, let me know if you have a preference for any of the roles. We'll be doing that all Tuesday and Thursday of next week. All right? All right, see you Thursday.